Recently, a division bench of Dr. D.Y. Chandrachud and Justice M.R. Shah upheld the order of the Chief Judicial Magistrate Thiruvananthapuram, who refused to consent to the application filed by the public prosecutor under section 321 CRPC for withdrawal of a criminal case filed against 6 MLAs in relation to the ruckus and damage of public property caused by them in an unfortunate incident that occurred in the Kerala Legislative Assembly in March 2015. Earlier, the Kerala High Court too had affirmed the order of the Chief Judicial Magistrate. So what really happened in 2015? On 13th March 2015, the then Finance Minister of Kerala was presenting budget for financial year 2015-16 in the Kerala Legislative Assembly. The accused, that is, the members of the Legislative Assembly, disrupted presentation of the budget, climbed over the speaker's dais and damaged furniture and articles including the speaker's chair, computer, mic, emergency lamp, electronic panel, causing a loss of Rs 2,20,093. How the case reached the Supreme Court? Let's know about it. The Legislative Secretary then reported the incident and a criminal case under section 447 and 427 read with section 34 of IPC, that is the Indian Penal Code, and section 3 clause 1 of the Prevention of Damage to Public Property Act 1984 was registered against the 6 accused MLAs. Investigation was completed. Final report was submitted and cognizance was taken by the additional Chief Judicial Magistrate Immaculum. Then election happened in 2016 and LDF party formed the government in Kerala, and in the year 2018 the public prosecutor filed an application before the Chief Judicial Magistrate under section 321 of CRPC seeking sanction to withdraw the case against all the accused MLAs, which was declined by the CJM. The state government then moved to the High Court against the order of the CJM, but the High Court affirmed the order of the CJM. Consequently, the case reached the Supreme Court. What was the contention of the state? State was trying to use Article 194 of the Indian Constitution. Article 194 of the Constitution provides for privileges and immunities of MLAs. Article 194 clause 1 recognizes the freedom of speech in state legislatures. However, this freedom is subject to provisions of the Constitution and standing orders regulating the procedure of state legislatures. Article 194 clause 2 enunciates a rule of immunity which protects an MLA from a proceeding in any court in respect of anything said or a vote given in the legislature or in any committee of the legislature. Moreover, it provides a shield against any liability for the publication of a report, paper, votes or proceedings by or under the authority of the House. Now, very important thing to note here is that Article 105 of the Constitution provides for privileges and immunities to the MPs. Now, what did the Supreme Court say? The Apex Court concurred with the decision of the High Court. Two key takeaways from the judgment are: first, no member of an elected legislature can claim either a privilege or an immunity to stand above the sanctions of criminal law, which applies equally to all citizens. Second, acts of destruction of public property in the House cannot be equated with freedom of speech. What does the judgment imply? Legislators charged with unruly behavior that results in offences under the penal laws cannot be protected either by their privilege or their free speech rights. Legislative privileges cannot be extended to provide legal immunity to criminal acts committed by lawmakers. Destruction of property cannot be considered as a legitimate protest. What did the Supreme Court comment on the privileges and immunity? Let's understand this. Privileges and immunities are not gateways to claim exemptions from the general law of the land. particularly as in this case the criminal law which governs the action of every citizen. The purpose of bestowing privileges and immunities to elected members of the legislature is to enable them to perform their functions without hindrance, fear or favour. These privileges bear a functional relationship to the discharge of the functions of a legislator. However, Article 194 does not cover up criminal actions of the members of the Legislative Assembly. So this was the gist of the case State of Kerala versus K.Ajith. Happy learning.